the court's.
The court is wrong.
Well, you know, you have, everybody has an opinion, and it can certainly be reviewed at the appropriate time.
Copeland, he said these things. Why?
Okay.
Why do I have to bring it up? You should be bringing it up. This is crazy. This is like communist Russia. Mr. Williams is having the worst trial. So I am moving again to stop intimidating the witness by the prosecution, leave people alone, and stop accusing. You've allowed the prosecutor Love to accuse me of misconduct.
Oh, but you've also accused her of hold on. You have accused her of misconduct as well. And remember what I told you about your professional remember what I told you about your, and she's going to take me down as opposed to you. So when I start talking, stop talking, please. Okay? I'll let you complete your record. Okay?
I understand the one party talk. I got it.
All right. Okay. All right. So I told you, several times before, I told you and your colleagues, remember your professional responsibility. And let's not make this an ad hominem issue. I don't believe that either one of you are trying to do anything that would subvert your ability to practice law. So but
Ms. Love has intentionally lied to the court numerous cases.
Hold on. Let him finish. See, this is Mr. Steele. This is exactly what I'm saying. It is not a good idea to state that your brethren across the bar are lying, okay? In any time or any way.
I don't like doing it.
Okay, but don't. So don't. But don't because you don't have any proof. If you have proof of it, then if you have proof, there's a mechanism in law and under the rules for you to submit that question to the Office of General Counsel and for the investigation to occur. But please stop, both of you. I told both of you earlier, stop making these ad hominem attacks toward one another. Okay?
Everyone gets attacked. You say nothing.
Well, okay, but I've said something. You're going back to stuff that's happened in the past. So while I'm trying to deal with things that are current. So I told you all most recently, as of about a week or so ago, to stop all this. Remember I told you the world's watching you? They are. So please don't from this point on, do not accuse each other of anything. If you want to go ahead and do it, there's a proper way to do it, but don't bring it up in front of me. Okay?
I'm just making a point that this has been going on and it's abusive. That is my point.
That's your assertion, sir, as a lawyer, okay? And maybe your frustration with everything. Like I told you, this trial's gone on a long time. There's a lot of wear and tear, but everybody's got to rise above and be a professional advocate. That's what the system demands of you.
I'm not worn or torn. I am here to tell the court that from a objective, casual observer, could see what's going on here is inappropriate.
Okay. At the end of the day, I understand your concern that you have now shared with the court. Okay. All right. State, do you want to respond?
Your Honor, I just asked that the court strike the portions of Mr. Steele's, whatever that was, to the court regarding personal and ad hominem attacks on members of the state's team. Ms. Hilton will address the merits of the initial argument that Mr. Steele made. But as to personal attacks on members of the state's team, we'd ask that assertions that specific people have lied, that is disrespectful, that is unprofessional, and not one time has any such statement been made by any member of this team about anyone else.
Oh, I think, Ms. Love, in the past, you've made some statements.
I have never said anyone lied.
You've made some statements about Mr. Steele. And well, just let me finish. I'm not done. All right. And about several others of your colleagues. I mean, and it may have been the heat of discussion and everything else. Like I said earlier, there's enough blame to go around for everybody. All right. So, but can we kind of stop that and draw things kind of forward? I've had 2 or 3 conversations with everyone about their obligations as professional advocates under the rules. Okay. And that while the court certainly agrees that ad hominem attacks are not, they don't make anybody look any good. They really don't. I mean, but I'm just saying I acknowledge that. I acknowledge what's been gone on in the past. So, and I ask that you all reflect upon that because, you know, like I said, you can't say some of the stuff that people say to one another can't be taken back. They just can't. So, and that's just something that the court would just have you reflect upon.
Thank you,
Both
Judge.
sides, okay?
And we just ask again that statements like Miss Love lied be stricken from the record. Those are personal attacks. There's none been made, at least not this day.
I'm not gonna consider your ad hominem attacks. Either one is, okay?
Thank you.
Or anybody's, all right? Okay. All right. Madam.
Your Honor, regarding Mr. Steele's assertions of our interactions with Mr. Copeland, we have not treated Mr. Copeland any different than we would treat any of our other witnesses in the state of Georgia. He is our witness. If he wants to be around us, he can. If he chooses not to, he doesn't have to be. The fact that he's saying we are coercing Mr. Copeland to speak is clearly not true given Mr. Copeland's testimony here today. If we were coercing him to speak, he would answer my questions and I would not have to sit here and go in a back and forth and struggle with him. So clearly we are not being influential on Mr. Copeland given our interactions with him outside of the courtroom. So again, Your Honor, there's nothing inappropriate about the state's interactions with Mr. Copeland. He is the state's witness. We can't interact. We have not influenced any of his testimony, Your Honor. And so we ask that, I don't know if it was a motion, be denied if that was what was being asked of the court.
All right. I'll include the state's Exhibit 400, the statements of the most recent email that you have disclosed to the defense in this case, for purposes of the record, and I will also, to the extent that I don't think of. Mr. Steele, let me just make sure. Are you again moving for mistrial, or did you make them within your statement? Did you ask the court for a mistrial?
Yes, it's the totality of what I said. Yes.
Okay, I'm going to deny that motion, and I will also note for the record that it was that the same was positive for the next question. Okay. All right, Mr. Matthews, you're eating up your lunch. Okay, so.
I just want to put on the record that based upon my vantage point in the courtroom, I have a unique place where I'm able to see the jury, I'm able to see the witness, and I'm also able to see the vestibule out here. And on yesterday, I just want to be clear that it's not only observed back here, but I have a unique place, and I observe a very large individual standing outside of that door, those two doors, staring at the witness during this testimony.
I noticed a large individual too. There's plenty of large individuals. They're law enforcement, or we don't know, but I know
it's law enforcement.
Well, who is it? What's their name?
I don't know.
Okay, well then we don't know it's law enforcement. But I have the same or better vantage. I have the same or better vantage than you do. And I certainly, you know, think that for reasons that we don't know, that law enforcement stand in that door for security posture, and that's the only reason that they're at that door.
Well, I understand. I'm just putting on the record.
Okay, well, when this is reviewed, and the court's going to look at what the court saw as well. So if you're thinking that there's intimidation or otherwise, I'm telling you, and I'm putting on the record for purposes of the record, that there are many law enforcement that sit in both doors of this courtroom for that reason and that reason only. And unless you can tell me who specifically was standing out there, as you say, and Mr. Steele said, looking at our witness, Mr. Copeland, then I don't see that. Okay? Thank you, sir.
Thank you, Judge.
All right.
Briefly, Your Honor, since no one wants to go on to me, I saw the same thing that Mr. Matthews saw yesterday with the
How did you see him? Your back's to the door.
Are you questioning whether I saw him or not?
I'm asking how you saw it.
I pivoted around and saw him.
Okay.
All
right.
And because that we've seen people outside that door for 18 months, Your Honor. This person yesterday was glaring through that glass for at least 10 to 15 minutes that I noticed, boring a hole into the witness. So I just want to add that that is what I saw. I don't know his name. I don't know if it was law enforcement. I believe it was. I have not seen any other individual with law enforcement do that to that witness or any other witness during the course of the trial.
Okay.
Thank you.
Thank you.
Your Honor, just so that the record is clear, could they give more detail? Because there's no member of the state that fits that.
Yeah, I don't need.
And I
he
have
was
no
a
idea
gentleman
what
yesterday dressed in black or dark clothing. That's what I saw.
Also, yes, Your Honor, and I don't know. We don't know who they're talking about, what they're talking about. Literally, no idea. So the idea, this insertion into the record of the insinuation that someone is intimidating anyone.
I'll also ask Captain Kendall to ensure that only law enforcement are allowed back there in the vestibule, so that that if there's any issue with anybody looking in the courtroom, that is removed. So, all right.
Thank you.
All right.
This is an easy one. And I don't know whether this is something that the court can give an instruction in regards to. I want the folks to just take notice of it. We've had some discussions before about the configuration of the courtroom. There's a lot of folks in here. We've got jurors who are sitting right there on the front row who are closer than they would normally be to the parties in this case. I've noticed over the course of the last number of weeks and months, quite frankly, and I'd like the court to either remind the state, or maybe because it could be inadvertent, but maybe they can take note themselves of the fact that sometimes their facial expressions, their reactions, their statements to each other, their conversations to each other are done so close in the presence of the jury that it can't help but impact the jury. There was one time last week where Ms. Hilton was attempting to introduce a document, and there was some frustration because there's an objection, and Ms. Love reaches over and says, and I could hear it from over there, just show them the original. Just show them the original. And you know, those type of conversations and you know, when someone's upset with a ruling and roll their eyes or makes a facial expression or throws up their hands in front of the jury, 2 or 3 feet away from the jury, can't help but impact the jury. And so if the court needs to just remind the parties that we've got a jury that can be impacted and they need to be a little bit more circumspect, they can do that. Or perhaps my colleagues across the aisle can take note of that themselves and act accordingly.
All right, sir. Yeah, there's not a lot of room, and I wish you had brought this up earlier, but I certainly agree with that. I'd advise all counsel to just be mindful of their reactions as the jurors watch everything, okay? All right. Mr. Short, did you have anything else? I know that.
No, I'm good.
Okay. Okay. All right. Okay. All right. Enjoy your lunch. We'll see y'all back about 1 o'clock.